Justice without labels. Why sovereign citizen is a dangerous slur, not a legal argument. Introduction. A growing legal concern. In courtrooms across the United States, a subtle yet dangerous practice has taken root. Litigants raising valid legal questions, often regarding commercial remedies, constitutional rights, or due process, are being silenced with a single label, sovereign citizen. This phrase is more than a buzzword. It's being used to stigmatize, defame, and dismiss parties before their arguments are even heard. At SBC University, we believe in empowering people with the knowledge of their rights and the tools to assert them lawfully. That includes knowing how to recognize and defend against courtroom tactics that violate due process. The weaponization of language in law. Sovereign citizen has become a weaponized label, deployed not as a legal classification, but as a prejudicial slur used to imply extremism, fraud, or criminality. Courts and government agencies have no legal basis for using this term as a substitute for argument or evidence. Let's be clear. There is no statute, rule, or court doctrine that defines or validates the term sovereign citizen. Yet, once this label is used in a courtroom, it has devastating consequences. It poisons the record, it creates judicial bias, it deprives the litigant of a fair and impartial hearing. What federal courts have actually said. Federal case law is unequivocal. Courts must evaluate legal claims based on merit, not stereotypes. Use of the term sovereign citizen to discredit a litigant's argument does not relieve the court of the duty to evaluate the claims on their merits. U.S. v. Phillips. Judicial integrity requires neutral evaluation of pleadings without prejudice based on identity or perceived affiliations. Caperton v. Massey. Even the appearance of bias violates due process. Offit v. U.S. The courts have spoken. Labels are not law. Legal and ethical violations. Injecting the term sovereign citizen into a pleading without sworn admission or factual foundation is not neutral. It's abuse of process, violating multiple legal standards. Rule 11b-1 of the Federal Rules of Civil Procedure, improper purpose. Rule 11b-3, lack of evidentiary support. 28 U.S.C. 1927, multiplying proceedings unreasonably and vexatiously. Worse, this label can qualify as defamation per se under civil law, especially when used by government actors under color of law. Real-world impact, prejudice in practice. Using this term implies criminal behavior, domestic extremism, anti-government ideology. Yet none of these assumptions are supported in court unless facts and evidence are presented. Still, thousands of pro se litigants have their cases derailed by nothing more than name-calling. This is not justice. This is judicial profiling. SBC University's position. At SBC University, we do not promote unlawful behavior or political extremism. We teach our students how to navigate the Uniform Commercial Code, how to assert contractual and constitutional rights legally, how to engage with the court system respectfully and effectively. And we demand that courts treat every individual with dignity, neutrality, and fairness, regardless of what claims they bring or what terminology they use. Action steps for litigants. If you're ever labeled a sovereign citizen in court, here's what you can do. Number 1, file a motion to strike the term from the record. Number 2, demand evidentiary proof if the label is used by opposing counsel. Number 3, cite federal case law affirming your right to be heard on the merits. Number 4, call out bias where it appears, even if subtle. And number 5, document and object to every use of inflammatory language. Want help drafting these motions? SBC University's legal literacy courses can guide you step by step. Final thoughts, law over labels. The courtroom must remain a place of truth, not tactics, a place for justice, not judgment, and above all, a place where your rights are respected, not erased by a label. Let's call it what it is. Sovereign citizen is not a legal term. It's a slur. And in a just system, slurs have no standing. Stay informed, stay empowered. Subscribe to our SBC Insider newsletter. Enroll in our course, Due Process and Defamation in the Courtroom, or book a consultation with an SBC advisor today. SBC University, Powering private knowledge, preserving public freedom.